welcome to the 18th episode of the 39A podcast. For our new listeners, Project 39A is an organization that conducts interdisciplinary research on a range of issues dealing with the criminal justice system. I'm Anupriya Dhonchak, a law graduate from National Law University, Delhi, currently pursuing an MPhil in law at the University of Oxford. In today's episode, we are in conversation with Dr. Aparna Chandra. She is an associate professor of law at National Law School, Bangalore. She researches and writes on constitutional law, human rights, gender in the law, and judicial process reform. She collaborated with the Center for Reproductive Rights, New York, and undertook a study on legal barriers to accessing safe abortion services in India, parts of which we will be discussing today with a focus on the criminalization of abortion. I've had the good fortune of being taught by Professor Chandra, so please excuse me if I slip up and call her Aparna ma'am instead. I'm amazed by her ability to package such complex insights in the simplest of language. So as I welcome you to the podcast, Dr. Chandra, I'm very excited to have this conversation with you.
Thank you, Anupriya, and thank you for that very generous introduction. And you, of course, were part of that project that we undertook with the Center for Reproductive Rights. So very excited to be in conversation with you once we've had the opportunity to, spend some time reflecting on all the learnings that we had from that project.
So jumping right into it, this conversation is occurring in the context of the recent US Supreme Court judgment in Dobbs v. Jackson, Women's Health Organization, which held that there is no constitutional right to abortion by overruling the 50-year-old landmark decision in Roe v. Wade. Back home, the Indian Supreme Court's recent judgment in X versus Principal Secretary of Health and Family Welfare held that the Delhi High Court had taken an unduly restricted view in not allowing a woman to terminate her pregnancy at 23 weeks, just because she was unmarried. Indian media reported the judgment with smug headlines, claiming we're not like the US. So, on the one hand, our judgments will talk about ensuring the highest standards of sexual and reproductive health for women, claiming that criminal law cannot unduly interfere with personal autonomy, and particularly Puttaswamy, which recognized reproductive autonomy as a facet of the fundamental right to privacy. And on the other hand, access to safe abortion in India is riddled with so many legal and societal barriers. The Medical Termination of Pregnancy Act basically creates an exceptions-based regime. So could you please shed some light on this huge gap between ground realities versus grand rhetoric when it comes to accessing safe abortion?
Sure. Thanks for that question. We see two kinds of rhetoric around abortion in India. One is the general abortion stigma, because of which there's the assumption that all abortion is illegal. And we see that quite a bit in practice. When we spoke, for example, for our report and our study, when we spoke with women on the ground who accessed abortion, they've gone in accessing abortion thinking that what they're accessing is illegal. We've spoken to doctors and other service providers who've thought that access to abortion is illegal, either illegal per se or parts of it being illegal. Some of that actually comes from, weirdly enough, medical textbooks, which talk about quote unquote illegal pregnancies, and they call any pregnancy that takes place as a result of an unmarried woman exercising sexual autonomy as being illegal. So there is this entire, abortion stigma discourse, or a discourse grounded in abortion stigma, which assumes that all abortion is illegal. And that obviously comes from a range of sort of moralistic assumptions about abortion, but also about particularly women's role in society and myths about motherhood as being the norm for women, because of which abortion is obviously considered illegal. So there is that a bit of rhetoric, right? And then on the other hand, we are seeing, particularly after this Dobbs judgment, this self-congratulatory rhetoric about how India is so much better and so much more liberal than the US, because we have, since 1971, the Medical Termination of Pregnancies Act, which does provide for abortion. As you mentioned, it's in fairly restricted circumstances, but the idea that we have a right to abortion, I mean, that's the rhetoric at least, right? The reality, of course, is neither of those things. The legal framework within which abortion operates is this: the Indian Penal Code criminalizes abortion, and it criminalizes women who are seeking their own abortion, right? So that is the norm. The exception to that is the Medical Termination of Pregnancy Act, which comes in 1971 and was substantially revised last year in 2021. And that says that a doctor will not be prosecuted under the Indian Penal Code if the requirements of the Act are met. What are the requirements of the Act? The requirements of the Act are basically that abortion can be provided if the doctor is satisfied that it is required for the physical and mental health of the pregnant person, of the pregnant woman in the terms of the Act, or if the fetus has certain impairments because of which either it's not compatible with life, or the child to be born will suffer from significant disabilities, right? So that's broadly the framework, but it is the doctor's call on whether abortion should be provided or not. It is not the woman's decision. There is no abortion on request in the Indian framework. And apart from the doctor being the decision maker in this process, there is also now, after the 2021 amendment, medical board that can make determinations for whether abortion should be provided post 24 weeks. So there is this entire range of decision makers that the law has created. On top of that, the judiciary has created its own additional layers of judicial authorizations, as a result of which there are a range of people who make decisions about whether a woman can get an abortion or not. But the woman herself is a marginal player there. Her consent is obviously required, but her consent is not enough.
Right. Thank you so much. And that makes me think also about the medicalization of mental health, particularly because the Act in itself words impact on mental health in a very broad fashion. But because mental health has been over medicalized and with the involvement of the medical board, and when it's combined with the fear of backlash from authorities enforcing criminal law and patriarchal values, that also leads to a range of consent and documentation requirements, which make it very difficult for women to access abortion. So I was also wondering if you could talk a bit about medicalization of consent and also of mental health when it comes to accessing abortion.
Right. So let me take that question in two parts. One part is to do with how the processes under the MTP Act play out, right? So the MTP Act essentially says that the doctor has to, like I said, one registered medical practitioner up to 20 weeks now, two medical practitioners within the space of 20 to 24 weeks, and a medical board beyond 24 weeks have to take a call whether the requirements under the Act are being met and an abortion should be provided or not. In doing that, at least the doctors, the registered medical practitioners, have to keep in mind the foreseeable social and economic environment of the pregnant person. Now, that to me sounds quite weird, that you're asking a doctor who is potentially meeting a patient for a half an hour at max, a half an hour diagnosis or interview meeting, to determine what her reasonably foreseeable economic and social circumstances might be. As my students very often point out, you're assuming that the woman is actually going to tell the doctor, for example, things like domestic violence, is going to tell the doctor immediately that, see, I don't want to carry this pregnancy to term because I am in an abusive situation, etc., etc. Right? That she will necessarily be forthcoming about her social and economic circumstances with her doctor. Right. So there is this, and then of course underlying that is the assumption that the doctor is the best judge of the reasonably foreseeable social and economic circumstances of the pregnant person, which might impact her ability to care for a child if the pregnancy is taken to term. Right. So I mean that itself betrays discomfort with women's decision making, right? With the idea that women can be autonomous decision makers and they know what is good for themselves. And then you see all sorts of assumptions about, women will take rash decisions and hasty decisions and etc., etc. And in assuming that women are not reliable decision makers and someone else has to make that decision on their behalf. So medicalization of some of these decisions is itself very problematic. What happens as a result is that for women to seek abortion, they have to fit themselves into one or the other of the slots, right? That the exceptions that the MTP Act provides. And the slot that if you can't show that there's a fetal impairment, or if you can't show that there is a physical health issue that the pregnant woman is facing, then of course the remaining catch-all category is mental health. And while on the one hand, of course, carrying a pregnancy to term when the pregnancy is unwanted or unintended is, of course, traumatic, the need to label it as a mental health issue itself assumes that the decision on whether to carry a pregnancy to term or to abort is located within this framework of mental disturbance and mental illness and mental trauma, which may not be the case. I mean, there's the assumption that women will naturally choose motherhood, and therefore any kind of it's only distress, right, that will that will force them to towards abortion. And that again makes assumptions about women and their roles in society, and sort of the motherhood myth about how women are inherently nurturing and caring and should be inherently nurturing and caring, and it's only within exceptions such as when there is distress and you have to show that distress and you have to perform that distress, only then are you entitled to abortion, right? So I mean there's a whole concern about the underlying assumptions about women's roles within this framework. To the second question that you asked, right, of consent and the medicalization of consent, what the MTP Act framework does for consent, I should say, apart from the Indian Penal Code, there are a range of other laws that impact a service provider's decision, a registered medical practitioner's decision of whether to provide abortion or not, right? So there is, for example, the POCSO Act, the Protection of Children from Sexual Offences Act. Now, what POCSO does is that it criminalizes all sexual activity, whether consensual or not, between people under the age of 18. Right. So and it says that anyone who has information or even an apprehension that there is likelihood that an offense under this act will be committed is mandatorily required to report the same to the police. Right. And then if they don't, then there are penal consequences. So there's a mandatory reporting requirement for any sexual activity under the age of 18. What does that mean? That if someone is seeking sexual and reproductive health services under the age of 18, they're already within the zone of criminalization. And if the doctor either knows that they've engaged in sexual activity, so for example, someone going to seek abortion services, obviously there's been some sexual activity at some point, whether consensual or not, or if the doctor has an apprehension that there might be the person might be engaging in sexual activity, such as when someone goes to seek counseling on birth control methods and contraception, the doctor is required to inform the police. So there is that entire POXO framework. The other law, of course, that comes into the picture is the PCPNDT Act, the Preconception Prenatal Diagnostic Techniques Act, which prohibits sex determination. Now, it prohibits sex determination. It doesn't actually talk about sex selection. So it doesn't talk about abortion. But in the policy making level, a lot of the focus of enforcement of PCPNDT is on abortions. Right. So when doctors are performing abortions, they are in danger of being caught up within the enforcement mechanisms of the PCPNDT. So as a result, what happens is a lot of doctors are very wary of getting caught up within the criminal justice system, right? If there is some box that they haven't ticked under the MTP Act, the exception of the MTP Act does not apply, and then they're open to prosecution under the Indian Penal Code. POXO is something that they might find themselves liable under. PCPNDT is something that they might find themselves liable under. The range of state-level drug laws, etc., that are putting another layer of complications in terms of accessing abortion. So all of this has a very chilling effect on practitioners, even if they are otherwise inclined to provide abortion services. And that by itself is by no means guaranteed. Like I've already said, doctors are themselves they themselves part of society. The general prevalence, prevalent notions around abortion and abortion stigma apply to them as well. Patriarchal notions about women's role in society apply to them as well. And their own medical education very often tells them that abortion is, something that is in the zone of illegality, right? So it is within this framework that service providers are operating. So when someone goes to a service provider to seek abortion, the easiest thing for them to do is to deny abortion. Even if they're inclined, because there's no consequence to denying abortion. If they were to provide abortion, then they have to. Then there's a whole range of regulatory requirements that they need to meet. So what do doctors do? They practice fairly defensive medicine. What they will do is they'll make the pregnant person run through hoops. They'll say, okay, get consent from your spouse, get consent from your parents, get consent if you have neither spouse nor parents, get consent from the state, someone other than you, because we don't just trust you as a woman to take this call on your own. So someone else's consent is required. None of this is within the letter of the law, but there's this additional kind of consent requirement, documentation requirement to say, okay, give us 10 different forms of proof of identity, get a letter from XYZ to make sure that everyone knows that you're getting an abortion, and that tomorrow if something happens, I can turn around and say that, this was not my call. There was someone else who took responsibility for this decision. This wasn't my decision alone, and that consent was established. So women are made to jump through hoops again, because women's decision to seek abortion is not really trusted. Doctors will say things like, why don't we come back after 2 days, 3 days, and then let's take a call on this. So a cooling off period. They'll try and suggest to the woman, or try and quote unquote counsel her as to why abortion is bad for her, how she will regret that decision. The interesting parallel here with the US is that in the US, many state laws actually provided for these kinds of mechanisms to regulate a woman's decision to seek abortion or not. And the US Supreme Court had in one of these cases that was struck down in Dobbs, had said that you can't place undue burdens on women who are trying to seek abortion. In India, while the law on the face of it doesn't require any of these things, in practice, doctors adopt very, very similar kind of burdens that they impose on the woman when she's seeking abortion. And that, of course, has a huge impact on women's ability to access abortion, particularly women who are in impoverished circumstances, who can't keep coming back to the hospital, or who are in family circumstances where they don't have family support for either generally or for their decision to seek abortion. And of course, women who are pregnant outside of the framework of marriage and might not want to inform their family or other people, right? So in that sense, these kind of defensive practices of seeking additional consent and documentation requirements places a huge burden on women who are seeking abortion. Very often, they just go away, and then you don't know what happens to them, right? There's a saying within even the medical community on abortion that any person who wants an abortion will get an abortion. The only question is whether they will get a safe abortion or not. So you don't know where they're going to seek their abortion, seek an abortion, if that's not happening by a registered medical practitioner.
Right. Thank you so much. For the first bit, I had a question, and I think that's a good seg into the next question. So, on the question of over-medicalization of mental health, you talked about how women are burdened, women shoulder the undue burden of having to perform that they have undergone grave distress, and they're at the risk of grave injury to their mental health to be able to get an abortion. And on the other hand, there are enough scientific studies corroborating the fact that carrying an unwanted pregnancy to term by itself would cause a grave risk to the mental health of all women. So that by itself should not require any additional corroboration, and it should automatically mean that if a woman is unable to access safe abortion, that will impact her mental health. This also made me think about whether the perception of the law as too liberal or too restrictive has an impact on the ground when it comes to accessing abortion, because I think one of the counterintuitive findings of the study also was that often perceiving the law as too liberal leads to policing by the personnel involved in enforcing the law, both medical personnel and state authorities. But also that sometimes perceptions of the law as too liberal can actually help women access abortions, because people believe that regardless of their personal beliefs, the law actually requires them to abort in certain cases.
Right. On the first part about the distress that is caused by carrying an unwanted pregnancy to term, there is a medical question there, right, of what is the impact on a person from carrying an unwanted pregnancy to term. And I mean, there's a fair medical question to ask. But in the realm of the law, I would think that the question has to be, can the state coerce a person to use their body for ends that the person does not want to use their body for, right? This is a question about state power. What can the state coerce a person to do or not to do, right? And that's a question about bodily integrity. That's a question about privacy. That's in the case of abortion, also a question of equality. And in that sense, I don't know that the question of whether it causes mental distress or not is something that should necessarily be relevant to the state's regulation of abortion. The assumption that all women will be equally mentally distressed with an abortion, like I said, assumes that abortion is the exception and carrying a pregnancy to term is the norm, and therefore the decision to abort is something that's a very traumatic decision. The flip side of working within this framework is also to therefore say that, women will come to regret this decision later, and therefore, they need to be counseled, they need to be made to understand all the consequences of their action, and so therefore there's very intrusive mental health counseling, etc., etc. And we've seen that actually with medical boards, where medical boards will sit and do, or doctors will sit and do this kind of counseling of women to try and convince them to keep the pregnancy. In fact, we saw this play out very weirdly in the Delhi High Court a couple of weeks ago, where the judge who was hearing a matter in an abortion related case said that this is carry the pregnancy to term, and I will raise the child, or I will pay for raising the child, give it up for adoption. So this kind of an assumption that that abortion is the exception, carrying the pregnancy to term is the norm for women, the gendered expectation for women, and therefore if women are seeking an abortion, therefore it must be because there is mental trauma, is something that, while empirically might be true, because women are also subject to these or very often also internalize very many of these gender norms, but I think should be irrelevant to how the state looks at this question. I mean, the only thing I think for the state to know is if it thinks of women as, as agents of their own lives, and as people who have all the rights that are available to a citizen or a person in this country, then the only question to ask is, can the state coerce someone to use the internal organs of their body for purposes of the state or for purposes of another, to sustain another life? And that's the question that needs to be asked, rather than what is the impact of it on women. Right. So that's broadly my response to that first part that you said. On the second bit that you talked about what happens when there's a perception that the law is too liberal. Now, as you noted, this was the counterintuitive element of our study. So, around the world, there has been a movement towards the decriminalization of abortion. And the idea is that you take it away from the criminal law framework so that, service providers don't have a legal impediment in providing an abortion. We found counterintuitively that many abortion service providers were actually had much more abortion restrictive views, personal views on whether abortion should be provided to women or not, and felt that the only reason why they had to provide an abortion was because you actually had a law that allowed for abortion to be provided. So many of them said, this law is too liberal, but what can we do? The law is giving people the right, quote unquote, to get an abortion, so we have to provide them an abortion. And I think the big learning from that was that decriminalization of abortion in India is necessary, but it's not sufficient. We have to supplement that with some kind of an affirmative right to abortion and an affirmative right to get an abortion, at least within the public healthcare system, where the denial of abortion itself leads to some consequences, whether they be criminal or civil or what have you, but that we need an affirmative right to abortion. Just decriminalizing abortion and removing the criminal law provisions in the Indian Penal Code and scrapping the MTP Act is not going to be enough. So decriminalization, therefore, in India is necessary, but I don't think it's sufficient.
Right. And also, I thought, in light of the Dobbs judgment, there was a lot of opinions that this will ultimately disproportionately impact poor women and women of color who lack the resources to travel to other states or countries that allow access to abortion or access to expensive contraceptives. And even throughout the study that you undertook, there were quotes from areas like Ranchi, which highlighted how differential this access to abortion is. So, if you'd want to talk about how it disparately places, like you already spoke about, how abortion places an unfair burden on women, how it places a more unfair burden on women who belong to certain strata of society.
Sure. Let me just first say something about the Roe and Dobbs framework in the US context, and then relate it to what we're finding in India. So, the court in Roe, of course, very famously located the right to abortion within the right to privacy framework, right? And the understanding of the right to privacy framework, at least in the US and at least at the time of Roe, was the right to be let alone, the right to be let alone from government interference, which meant that abortion was a private decision and it was not the state's business to to determine whether someone should get an abortion or not. And there have been a lot of criticism. There has been a lot of criticism within the U.S. as well of the move to placing abortion within the right to privacy framework, as opposed to, say, the right to equality or the right to dignity framework. And why is that the case? So, the Black women's movements very famously again argued that for them, the concerns that they have in terms of accessing abortion or accessing reproductive care more broadly, whether it be their decision to, keep a pregnancy and continue a pregnancy to term, or the decision to abort, is of course determined by their material circumstances and their lack of access to adequate health care, to informed decision making, to structures of support such as childcare, state aid, etc., etc. And they said, therefore, that this idea that abortion should be kept within a framework where the government can say, okay, you go do your own thing and we will not bother about it, was particularly problematic for them, because they required the state to step in and provide the support structures within which they could make decisions of whether to keep a pregnancy and carry a pregnancy to term or to terminate the pregnancy. And so they said that what we need is to place reproductive rights within a framework of social justice, and they called this the reproductive justice framework. Right now, so therefore they brought in an element both of intersectionality, but the idea that the material, social, and economic circumstances of a pregnant person determines their decision of their the range of sexual and reproductive decisions that they make. Now, based on this, an argument has been made that the right to abortion should be better placed within the right to equality framework rather than the right to privacy framework, both because, of course, the ability of a person, of a woman in particular, to carry a participate equally in all avenues of life is impacted both by carrying a pregnancy to term, but also with child rearing, which is in our gendered societies falls disproportionately upon women. Right, so that's a larger two-pronged attack on placing placing abortion within the right to privacy framework. In Dobbs, this equality argument was sought to be made by some of the interveners in some of the amicus petitions, but the court summarily rejected that argument. They said Roe was decided on the basis of privacy, so they focused only on the right to privacy. Now, if we take this this experience in the US to the Indian context, we see something fairly similar playing out, right? Women seek abortion for a range of reasons, and I don't think we can. Some of them are personal, some of them are social. We can't have a comprehensive cataloging of why women seek abortion, but one subset of those reasons definitely has to do with their social and material circumstances, right? About whether they have the ability to carry the pregnancy to term, to rear the child within their familial context or their other social and economic context. What will be the impact of that upon themselves and upon the child to be born, upon their families, upon their ability to work, so on and so forth. So there is that element that's already built into the decision about whether to seek abortion or not. The second element is about accessing abortion once a woman has decided that she wants to terminate the pregnancy. Now, there is a whole architecture of of the public healthcare system, for example, where you have community health centers, you have primary healthcare centers, community healthcare centers, district level, tertiary healthcare centers, so on and so forth, right? And what we see is that both as a result of the laws that we have in place, the rules that we have in place, but also doctors' general discomfort with providing abortion, is that women are made to run from pillar to post. Abortion is not very easily accessible at the local level. Particularly abortion in advanced stages is generally referred up to a tertiary care hospital, and there again, if you're made to run around and jump through hoops in order to access that abortion, that means you have to keep coming back. Particularly for, say, example, daily wage earners, you can imagine that they have to keep coming back, losing their day's wage in order to get an abortion. And of course, in the Indian context, this sort of impoverishment and lack of access to material resources coincides with other markers of social marginalization, right? Caste, class being amongst the amongst those categories. So you can imagine how access to abortion, therefore, is mediated through the lens of all the social markers of identity. And then there will be all sorts of stigma that is associated with particular identities. So we found in our study a complete absence of any discussion on of the access to reproductive health care for trans persons, right? Particularly trans men. Many doctors just looked at us with bewilderment when we even spoke about this. So you can just imagine the level of lack of access to reproductive care in those circumstances. And then there are all sorts of myths and stereotypes that are associated with women who belong to certain castes and communities. So we saw, for example, in our study in places like Jharkhand, there are all sorts of myths associated with how tribal women approach sex and tribal societies approach sex and reproduction, and doctors make their decisions on whether a tribal woman needs access to abortion based on those myths. So we heard doctors saying that in tribal societies, an unmarried woman having a child is not really a problem, and so therefore we don't really need to provide access to abortion to an unmarried tribal woman, right? So the access itself is mediated both by the material and social circumstances within which women who are seeking abortion find themselves, as well as very actively the myths and stereotypes that are associated with women from different castes and communities.
Thank you, ma'am, for giving such a comprehensive picture of why it's important to place an affirmative right to abortion within an equality context. I was also wondering, with respect to gestational periods, where do these limits come from when the World Health Organization has said that it's safe to basically get an abortion even beyond 24 weeks, which remains the upper limit in India. And because I understand that the pro life lobby is much more strong in the US than it is in India. And if we start thinking about it as an ethical question, how should we ensure that it is not divorced from concerns of sex discrimination and women's right to not be forced to use their body as a vessel for procreation?
Right. And, that really, in some ways, is the crux of the matter, right? On the one hand, if we believe in the right to bodily autonomy and bodily integrity, in women's rights to equality and right to health, including their mental and physical health, then that would push towards an understanding that you have an unconditional right to abortion. And then comes the question of, but what about fetal life? Now, there is no understanding necessarily that the fetus itself has rights as such, but even within the US framework, at least till we had the framework of Roe, the understanding was that the state has an interest in potential life, right? The state has an interest in reproduction and in preserving potential life. Of course, one question is, does this, even if we assume that the state has this interest, does this interest trump women's women's rights to bodily autonomy and integrity? And should the state have the power, even if it has an interest, should the state have the power to tell women that the bodies have to be used for purposes other than the ones that women want themselves, right? So that is, I think, the larger question. And to my mind, if we take the right to bodily integrity seriously and bodily autonomy seriously, then there is but one answer to that question. Now, where do the gestational limits come from? A charitable reading of the 1971 MTP Act would suggest that some of these gestational limits come from the state of science as it was at that time, where abortion was primarily a surgical procedure, and there were some assumptions about how safe those procedures were. Is one reading. It's perhaps too charitable a reading, but let's give them that. Today, in the context of 2021, we know that abortion is a very safe procedure. In fact, the bulk of abortions take place within the first term. And the WHO says that at least up to 10 weeks, abortion can actually be managed at home with medical methods, right? With taking 2 pills. And that you don't actually need the intervention of a service provider even, right? So the WHO recommendations is at the level of self-management of abortion without the intervention of a service care provider in up to 10 weeks. Of course, as long as you have backup access to healthcare should you need it, and as long as you have adequate information. In the Indian context today, however, we still see that access to the rules under the MTP Act allow even for a doctor to prescribe medical methods of abortion only up to 9 weeks, right? So the rules are not in tune with the latest scientific understanding at all. They're still framed within the framework of surgical methods of abortion as being the primary method of abortion. And so therefore even the requirements in terms of who should be a registered medical practitioner, what kind of background experience they should have, what kind of facilities they should have access to, etc., is all geared towards a surgical method of abortion. Now, one way to justify all of this is to say this is for the health of the pregnant person and to protect the health of the pregnant person. But we know that that's not true, because much more advanced, complicated, dangerous, risky procedures, such as hysterectomy, for example, does not have any of these requirements at all. So this over sort of regularized regulations, over regulation of abortion clearly is for purposes of restricting abortion rather than because there's any scientific necessity or scientific basis to this. The ethical questions that come in, I think, are twofold. First is the question of sex determination and sex discrimination. I think that's a very, very important concern. But I think we have to ask ourselves whether prohibiting abortion and prohibiting women's access to abortion is the best way to regulate sex discrimination and fetal discrimination. We've seen that the sex ratios are falling regardless of the PCPNDT Act being there. So the question that we have to ask is, while we can all agree that the state has a very, very valid interest in prohibiting sex selection, the question that we have to ask ourselves is whether prohibiting or restricting abortion is the best way to get to that goal, right? Given the costs that women who are carrying unwanted or unintended pregnancies are the ones who have to bear the cost of this kind of an approach towards regulating sex selection. The second, I think, ethical question that we don't pay enough attention to is, you are, I think, asking doctors to terminate a pregnancy and end, to bring an end to the fetus at fairly advanced stages of pregnancy. I think that means that both we need our doctors to be trained to do that, and that might lead to a lot of ethical dilemmas for doctors themselves. And we have to have some system, at least, of managing those dilemmas, or sort of thinking about how best those dilemmas can be addressed. Ultimately, though, the question to my mind is, do we trust women to make decisions about their own bodies? Do we trust that if a person has carried a pregnancy up to, say, 25, 26, 28 weeks, and now no longer wants to carry the pregnancy to term, that there must be, for that person, some very compelling reasons from within their own lives why they don't want to carry that pregnancy to term, or why it is that it has taken 26, 28 weeks for them to come to that decision. And we allow them to sort of decide for themselves. To my mind, it is simply that question. There's a fantastic Bombay High Court decision on this. It's called it's a suo motu decision of the Bombay High Court, where the court really talks about this question about decisional autonomy, going back to the privacy framework, to say that we have to trust that women know what is best for themselves, for their lives, for any potential child that they might have, and to take a call accordingly.
Thank you so much, Dr. Chandra, for sharing your insights and giving us a complete picture as to how the law operates on the ground and the different personnel that are involved in enforcing it. So another thing of concern is the moral paranoia that service providers and courts often demonstrate when they're dealing with women having sex on their own terms outside of marriage, and the reluctance that they show in granting remedies to women. And that is deterred by requiring, for example, the husband's consent and signature on consent forms, or by treating a woman who's getting an abortion without her husband's consent as a ground for divorce, as something that amounts to cruelty. So if you could talk about this Indian institutions' general reluctance towards providing remedies to women who they think are not having sex within the limits and boundaries within which it is supposed to be had.
Right, you're absolutely right. Both the medical community as well as the judicial community really try to police abortion within the bounds of gender norms and sexual roles in society. So we see, for example, both doctors, determining whether access to abortion should be provided or not based on some of these norms. Actually, for unmarried women, it can go both ways. On the one hand, the assumption that if an unmarried woman is engaging in sex, then it is, as some of our interviewees said, that this is illegal sex, quote unquote, right? And if it's an illegal sex, then a pregnancy that results from it is an illegal pregnancy, and doctors need some involvement of the state before they can provide these abortion services. On the other hand, you also have many doctors telling us that, oh well, if this is an unmarried woman and she is not given access to abortion, then her future chances of getting married, her marriageability will be impacted, and so therefore providing abortion. But within all of these reasons, whether you're providing access to abortion or not providing access to abortion, is very much determined by your one's place within society and the social role that one is supposed to perform. We actually see this quite a bit also with disabled women, right? The forced sterilization of disabled women, which is the opposite of access to abortion, where disabled women very often do not have the ability to decide for themselves whether to conceive or not because of forced sterilization, or forced sterilization in camps in Jharkhand and Chhattisgarh and Orissa, which is again disproportionately impacting indigenous women, which is again based on some assumption about who are the women who should procreate, who should not procreate, and what are the circumstances under which they should procreate. I mean, very startlingly, and perhaps very honestly, the Statement of Objects and Reasons of the MTP Act 1971 says that, amongst one of the reasons why it is providing what it calls a liberalized framework for abortion is for purposes of eugenics, right? So it uses that phrase, eugenics. And that's very much also based on the understanding that, again, on what they see as the value of the life of disabled persons in society. Therefore, all this exception that is provided for fetuses that have impairment that might result in disability, substantial disability if the child were to be born. So therefore, these exceptions themselves are also based on some understanding of both, women's roles in society and women's gender roles in society. How they fit within the paradigm of good sex and bad sex, and good reproduction and bad reproduction, but also with respect to the role of persons in society like disabled persons. And all of that goes into the determination of who gets access to abortion, who doesn't get access to abortion, and under what circumstances.
Right, and I think that really shows the shortcoming of not placing our law within a substantive equality framework.
Absolutely. The idea of placing it within a substantive equality framework would also require us to look at, one is, of course, it would challenge the exceptions-based regime itself, but to also see what are the kinds of exceptions that you're providing. If you were to think of it as an exceptions framework still, what are the exceptions that you're providing and why? And what it does is it also forces women who are seeking abortion to frame their claims within these exceptions, right? And it brings into tension women's bodily autonomy and other societal societal concerns such as sex determination or selecting out disabled fetuses. And that is a kind of tension that the law is creating, because it is forcing women to make their decisions within the framework of these exceptions. So that's the question that one has to determine. I mean, again, these are very valid concerns for the state to have, but the question is, can you, just because you have a valid concern, does that mean can you burden the right of women to choose what to do with their bodies in the ways that in the ways in which the state has done? And can you put barriers in terms of accessing abortion for women on these kinds of grounds?
Thank you so much, Dr. Chandra, for telling us what is really at stake in conversations like these and how important it is for us to foreground these concerns instead of adopting a self congratulatory attitude regarding abortion rights, which we've seen in the media of late. Thank you so much for joining us.
Thank you, Anupriya. It's been a pleasure.